Hey everybody, John Skiba here, and in this video I'm going to answer the question of whether you really need to hire an attorney to defend you if you're being sued by a junk debt buyer. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on the little bell. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, let's talk about hiring an attorney to help you through your debt collection lawsuit. Now, the type of lawsuits we're talking about here, you've been sued by a credit card company or one of their collectors or by a junk debt buyer who's alleging that they purchased the debt. And you want to know if this is something you can do on your own or whether you need the assistance of an attorney. Now, first, obviously, I am an attorney. so this will probably be somewhat biased about whether you need an attorney. But that being said, you can, if you're familiar with my YouTube channel, I'm here all about providing information to people to help themselves as they deal with these very difficult problems. I recognize that when it comes to particularly junk debt buyer lawsuits, that often hiring an attorney is either not possible because you don't have the funds to be able to do it, or other times it just doesn't make sense. I can tell you how many people I meet with that are being sued by Midland Funding or Portfolio Recovery for literally $500 or $1,000 or $1,500. And it just doesn't make sense to bring an attorney in, spend a bunch of legal fees when you could really pay off the entire debt rather than pay the legal fees. So I want to discuss, though, 3 reasons why it may be worth considering hiring an attorney if you're representing yourself in a junk debt buyer lawsuit. The first one is actually not really a legal reason. It's that if you are representing yourself, you're going to see it takes over your life. You're not going to sleep well. You probably have a day job you're going to, and then you're going to come home at night to your new second job, which is researching things about your case, drafting documents for the court, learning the procedures of the court. And these things are not resolved quickly. Most courts are going to take, at a minimum, several months. I can tell you in Arizona, where I practice, even if you're being sued in the Justice Court, which handles matters that are under $10,000, you're looking at anywhere from 8 to 12 months to get a trial date. If it's more than $10,000, it could be up to 2 years to get a trial date. This thing will take over your life. And that's when having an attorney can actually help you out, because it turns into a situation where you can really just hand it off to them. You're involved, you're being updated, you're providing input, but you're not the one who's responsible for keeping track of the deadlines, for drafting the documents, knowing what the procedures are. All of that takes a big weight off your shoulders in having an attorney help you out in representing your defenses to the other side. The second reason is that there are some complex parts to junk debt buyer lawsuits. Now, what I mean by that, one of the biggest videos I've ever put out on my YouTube channel is how to draft an answer to a debt collection lawsuit. That's the very first step. When you get sued, in most states you have to file a written response to the creditor's complaint. That is a fairly straightforward document. All the court's really looking for there is whether you admit or deny the allegations that the creditor or the junk debt buyer are putting forth in their complaint. So you can literally admit or deny it, turn it in, send a copy to the other side, and you're good. You've avoided a default. However, things can get complex and can do so very quickly. Usually it's at the motion for summary judgment stage where most people run into problems. A motion for summary judgment is essentially where the junk debt buyer or the creditor is saying, hey judge, we don't need a trial, just look at all of our evidence, tell us we win. You have to respond to that, and then you have to respond to it substantively. You can't just say, I deny everything that they're alleging. You have to go through and pick apart their case and show why it is that judgment should not be entered. If you don't do that, judgment will be entered, your case is over, no trial. I often have people come to me and say, I didn't even get to go and share my side of the case to the judge because summary judgment was granted. That's what happens. If you lose at that stage, your case is done, and you're not going to have an opportunity to go to trial. So the complexity of it, particularly at the summary judgment stage, the trial stage is another one that gets very tricky when you're up there trying to do cross-examination, just knowing general trial procedures. The dirty little secret is a lot of attorneys don't even know how to handle trial, because civil trials just don't happen that much anymore. In Arizona, I saw a statistic that was pretty striking. Less than 2% of civil cases actually go to trial. But the attorneys that have actually handled like a civil jury trial, very minimal throughout our entire state. It's just not something that happens because most cases settle, because in the civil world at large, it's just too expensive to litigate these cases all the way through the end of trial. So the complexity is the second reason of why you may want to consider hiring an attorney to assist you with this. The third and final reason I'm going to share with you is the competitive advantage it gives you in trying to defeat the junk debt buyer. If you've been sued by a creditor, you are going to be going against not only the creditor, but their attorneys. This is not something where they're representing themselves or they're, you're dealing with someone who's also kind of learning the ropes. You're going to be dealing with an attorney who deals with these things all day long. This is all they do. They do trials, they do file the lawsuits, they do summary judgment motions. The courts are going to know who they are because these are big time repeat flyers when it comes to junk debt buyer lawsuits. So you are immediately at a disadvantage because you're dealing with someone who's been doing this for their entire career. Also, in most jurisdictions, Arizona, I know this is true, the court expects you and will hold you to the same standard as attorneys who are in the court trying cases. So they expect you to know the rules. They expect you to know the local rules. It's like the little hidden subset of rules that each court has. They expect you to know the law and the way to present things and how to make objections. They are going to impose those responsibilities on you, and that can be tough and that can be intimidating, and it can make it so that it's very difficult to win your case. So all that being said, I know a lot of people do this, and I see people every single day in my law practice who contact me for information or advice who have done a great job and have even won their cases and even gotten costs and stuff like that reimbursed from the debt buyer. So it's 100% possible. Those three reasons, though, are reasons you might want to consider if you're just starting out on this journey of whether do I need an attorney or not. There are times when it is completely necessary, just so it doesn't completely ruin your life and take things over. So, I can only represent people in the state of Arizona. I have put together some informational tutorials that will provide you a lot of information about how these cases are handled. I'll put a link for those down in the notes. But if you're just starting on this journey, trying to decide whether you need an attorney or not, hopefully these few items can help you in making that decision. Thanks for watching today.